Damages. Expectation damages is the standard measure of money damages. It puts the parties in the economic position they would be in if the contract had been performed, if the breach never occurred. Note, when in doubt, look for the answer that most closely gives damaged party what she would have received absent the breach. Reliance damages. This alternative measure is used when expectation damages are too speculative. Designed to compensate plaintiff based on the value of her performance and put plaintiff in the position they would have been in had the contract never been formed. Consequential damages are foreseeable losses indirectly resulting from a breach or loss of profit. Recoverable if 1. Damages are foreseeable result of the breach, and 2. When contract was formed, defendant had reason to know plaintiff would suffer special, unpreventable, or unexpected damages in the event of a breach. UCC contracts only buyers can recover. Incidental damages. Commercially reasonable expenses incurred by the non-breaching party in the UCC contract. Cost of inspecting, returning, storing, reselling goods. There is a duty to mitigate. Plaintiff cannot recover reasonably avoidable damages, but can recover the cost of avoiding further damages. Non-monetary remedies. In the event of breach, certain non-monetary remedies or equitable relief may be available if monetary damages are unavailable or inadequate. Their specific performance, which usually is only available for contracts involving real estate or unique goods, such as antiques or art. For service contracts, injunctions preventing breach may be available. Injunctions enforcing non-compete clause. Then there's rescission, which is a cancellation of a contract. The purpose is to restore parties to their position before the contract was made. This often arises where there is a mistake, misrepresentation, duress, or some other defense to contract, enforcement, or formation. Reformation, which is a remedy whereby a contract is changed so that it reflects parties' original intent. This can arise where there is a mistake in contract formation such that the final contract varies from a prior written agreement of parties. This can also arise where contract is inaccurate due to some misrepresentation. Reclamation. In a UCC contract, unpaid sellers may stop delivery or reclaim goods from an insolvent buyer. Unpaid seller generally cannot reclaim goods from subsequent buyers. Restitution and liquidated damages are additional damage types that may be available. Restitution damages arises where a party has been unjustly enriched, awarded based on the value of benefit wrongfully conferred. Party cannot recover both expectation damages and restitution damages. Liquidated damages, agreed upon contract provision that stipulates specified damages upon the occurrence of a breach. Requirements. Liquidated damages provisions are valid only if 1. Damages are difficult to project at the time of contract formation, and 2. The provision is a reasonable estimate of actual damages. There is a duty to mitigate. Plaintiff cannot recover reasonably avoidable damages. Plaintiff must refrain from incurring additional losses after receiving notice of breach. Plaintiff may recover the cost of mitigation or the cost to avoid further damages. In employment, plaintiff's damages can be reduced if defendant can show a comparable job in the same locale was available to plaintiff. Defendant bears the burden of showing plaintiff's failure to mitigate. Breach by seller and buyer keeps goods depends on if buyer accepts. So in a non-acceptance, damages equal the fair market value of perfectly delivered goods minus the fair market value of goods actually delivered. Acceptance, the damages are the difference in value between the goods as delivered and the goods as ordered. Note, if seller delivers non-conforming but superior goods, buyer is not responsible for increased value of superior goods. Breach by seller and seller keeps or buyer returns goods. Damages, whichever of the following is higher. A, fair market value of goods at the time of breach minus contract price, or B, buyer's cost of covering replacing goods minus contract price. Breach by buyer and buyer has goods. So the damages are the contract price. It arises if goods are kept by the buyer, destroyed after the ROL passes to the buyer, or returned and seller is unable to resell. Breach by buyer and seller has goods either A, contract price minus market price at the time of delivery, or B, contract price minus resale price, provable lost profits. Conversion is if the fair market value of goods at the time of conversion. And then there are losses, which is when the buyer and seller can also recover lost profits or damages for losses resulting from breach or non-conformance. Note, incidental and consequential damages may be available.